training event, or HR forum as we've called it in the past. As you can probably all see at the moment, you're all muted, but I'll come on to that in a minute because we want today's session to be a little bit more interactive, hopefully. You've probably done lots of Zoom sessions now and just sat there listening to people as I have, and we're hoping today's going to be a little bit more interactive. So if we go on to the next slide, Chris. So session plan for today, basically, we're not going to be our usual couple of hours as the previous virtual ones. We know on Zoom that's not a great idea. So we're going to probably chat for an hour or so, but that does include interaction. So today what we're going to have is we're going to talk specifically about disciplinary and dismissals in the new normal. That obviously involves the pandemic and people working from home, etc. But we're going to look at discussion points and case studies as we go through the session. So hopefully it's going to be a little bit more interactive. So as I said, you're all muted at the moment. If you do have any sort of slightly sensitive questions that you'd like to put on the chat box, or indeed you're just too shy to come up unmuted, then please do put them in the chat either openly or just to myself if you want to keep anonymous. And I will keep an eye on the chat box as we go through. But actually today we are encouraging you. We don't want obviously everyone unmuted all at once because we know about background noise on here. But if you do want to come in and join the conversation, by all means, please do unmute. As you can probably see in the top left-hand corner, we are recording today's session as we have done the previous virtual ones. And Jenny, who's also online today in the background, one of our marketing people who runs these sessions for us, she will send out the recording afterwards. If you aren't happy to be recorded, obviously do turn your video off and stay muted as well. Right, so as I said, today's session is going to be on disciplinary and dismissals on the new normal. Before I do that and introduce Chris again and lead, because he's going to start us off. First thing is the Queen's speech was obviously yesterday. I don't know how many of you kept an eagle eye on it. Chris and I did, of course. And damp squib, as we probably predicted, there was nothing about any real employment change at all. There was no new employment bill, as there may have been. In fact, there was very little of any substance at all when it came to business and employment. So it doesn't look like we're going to have any real meaningful changes, and certainly in the near future. Obviously, they're still focusing on us coming out of the pandemic as we open up indeed on Monday further. So I just wanted to point out, because that was literally yesterday, as some of you may have seen. As I said, today is going to be looking at disciplinary and dismissals again, but this time particularly focusing on issues during the pandemic and beyond, now that many of us are working in more flexible ways, certainly considering working at home and that. We've put a Q&A at the end, but as I said, we'd like to make this a bit more of an open discussion throughout. So I will now introduce Chris formally, who's on the line as well. As many of you know, and especially if you've been to the last few, Chris has now been with Threatons, getting on for about a year and a half, isn't it, Chris?
Yeah, just over 18 months, last week, in fact.
Yeah, ignoring bits of
furlough
and that. But Chris is going to start us off, just recapping really on disciplinaries and dismissals, fairness, etc. And can you hear me?
Yeah.
My screen's just gone completely blank.
Good opportunity for me to take over then while Paul
tries
to sort that out, I think.
An IT failure. Sorry, everyone.
Not a problem. Right, good morning then, everybody. Thanks for joining us. As Paul said, disciplinaries and dismissals today. So what I thought I would do is just start with a recap on disciplinaries. It's been a long time, I think, since one of these sessions has been sort of dedicated on disciplinary and resulting dismissals. So starting point, as Paul said, recap there, and then how a disciplinary dismissal is judged when it comes to fairness. So firstly, looking at the purpose of any disciplinary procedure or process, I think we instinctively feel sometimes that a disciplinary has come to mean the entire process is a punishment. We know this isn't the case, and that it should be initiated when wrongdoing has definitely occurred. I think when we're looking at discipline issues in the workplace, a slightly more holistic approach can sometimes be quite useful. So yeah, we all know there's times when you catch somebody putting their fingers in the till. The disciplinary process is, for lack of a better phrase, it becomes a bit of a tick box exercise, but it shouldn't ever be that. Yes, we want to ensure we reach a fair dismissal, but I think more broadly what we're aiming at is what I'm saying in the first bullet points on that slide there. We're looking to identify, or we have identified, unacceptable or inappropriate behaviour, and to remedy that in a way which doesn't necessarily require the full personal and professional disruption that comes from a dismissal. People don't like being sacked, funnily enough, and I hope most of us don't like sacking people. Assuming Alan Sugar's not on the line or something. Disciplinary processes which clearly build towards a dismissal are unpleasant for everyone because they're time consuming, they're stressful, and they're inevitable. Those almost tick boxy ones that I was mentioning earlier, we know are often a lot quicker. But the point I'm really making there on the second one there is, we're not predetermining this. We're not saying that dismissal is always going to be the conclusion of a disciplinary process. And I think that's an unhelpful approach to any disciplinary procedure anyway. What you're generally looking for is steps that can be taken to remedy the issue that you've identified and a satisfactory conclusion for everyone involved. Yes, again, there will be those times when dismissal is your only option for obvious reasons. But a lot of disciplinaries, as we know, come out of perhaps somebody else's grievance. You end up stuck in a situation between two employees there. And I think the job there is to identify what works on balance. Dismissal of a good employee because somebody else has complained about them probably isn't ideal for most people. As I say, it goes without saying that we shouldn't have decided from the start that individual A is going to end up being dismissed. Otherwise, you might as well have not bothered having the process. Just dismiss them on the spot if that's how we're going to start. More importantly, with the exception of those very rarely justified on-the-spot dismissals, an indication of a predetermined outcome gives a very clear route into an unfair dismissal argument. And there we go, hitting that word fair. We know that we want to avoid an unfair dismissal. We know that dismissal has to be fair. But the big question really is what do we mean by that? And that, I think, is what we'll go on to talk about. So dismissing somebody fairly, it is often an outcome to a disciplinary process. It's the one that we're most concerned about because it's the one that is most likely going to give rise to a legal claim against the businesses we work for and with. So we know that a fair dismissal is there in Section 94 of the Employment Rights Act. An employee has the right not to be unfairly dismissed by his employer. Again, not teaching to suck eggs here, but keyword there, employee. So we're obviously only concerned about employees when it comes to unfair dismissal, and we know we're only concerned about those who have got the full requisite service. Beyond Section 94, we then know that Section 98 sets out those 5 fair reasons for dismissal. And then we hit Section 98(4) as we keep working through the Act, which is where we get this wonderful turn of phrase, that whether a dismissal or not is fair depends on whether in the circumstances, including the size and administrative resources of the employer's undertaking, the employer has acted reasonably or unreasonably in treating it as a sufficient reason for dismissing the employee. It's classic awful statutory language. Breaking down those various sections of the Employment Rights Act give us what I think is this kind of 3-stage approach to looking at a dismissal and judging its fairness. And this is very much the approach that lawyers take in arguing it and that tribunals take in judging it. So firstly, of course, we're looking for a factually fair reason for dismissal. It's got to be one of those 5 acceptable reasons that's set out in statute. And in the case of a disciplinary, we know we're generally looking at conduct, Section 98(2)(b), for those of you who like statutory references, which is probably just me and Paul. Importantly, this also means that the individual should know what it is they're supposed to have done in relation to the disciplinary allegation. The reason can't logically be fair if the employee never knew what that reason was. And this means from the start of that disciplinary process, making it very clear what that unacceptable or inappropriate behaviour is that the disciplinary process is designed to be targeting. Ultimately, when this comes to a disciplinary hearing, that individual is defending themselves. And again, it makes logical sense to say they've got to be able to defend themselves against something they understand. Tribunals, as I've said there on the second sort of sub-bullet point, are a little bit more relaxed about the official designation in these cases. And this is where we're talking about one of those reasons for dismissal set out in statute. So if you are citing conduct in your response, but it's more appropriately, I don't know, illegality. Trying to think of a good example off the top of my head. Somebody loses their driving license because of road traffic violations, I suppose, in a job that requires them to have it. You could argue that's illegality, or if you've approached it through a disciplinary process, conduct. The tribunal really, I don't think, is going to penalise you for mislabeling that. It's fairly well established that you can get away as long as the ultimate reason is fair. So as I've said, it's easy to concentrate on this factually fair element and getting that right. And I think sometimes what that does is it leads to slightly convoluted allegations in investigations and disciplinaries. My thoughts on these is that they can be very, very simple statements, and they don't need to tell a story. So I always think the asserted statement in an allegation, certainly for that disciplinary letter, the notification of the investigation, the invite to the hearing, you behaved in an unprofessional, inappropriate manner towards X on the 2nd of April. I think that's all that needs to say for the allegation. The detail can come in later. I think the more that goes into that early bullet point and the more you get this convoluted narrative around what that allegation is all the way through, the more opportunity you have for somebody to start to question its accuracy, specific statements, what was said and how. It's personal preference. I know when I'm certainly drafting for the tribunal, I like to keep short and sweet. I don't know, Paul, whether you've got a different opinion on that.
For the tribunal, yeah. I suppose just jumping in, the only thing I will say is I agree with Chris, subject to the fact that obviously you need to put enough detail in so that the employee can then not complain at a later stage if they do take it on further that, well, I didn't really know what the allegation was. It was too vague.
Yeah,
that's the only thing just to keep an eye on.
Yeah. So I think what I'm getting at is certainly those they're often set out in 3 or 4 opening bullet points, aren't they? That very short, precise, I think I personally prefer. But yeah, I mean, I think those are the points from a factually fair point of view. It's a case of really just summarising those bullet points. What exactly are we going at here? Make sure the individual knows what it is they've done wrong so they can defend themselves. Keep that short and sweet enough that you haven't got an opening for somebody to question every part of it in detail and end up with a 9-hour hearing. But as Paul says there, with enough detail that somebody can know exactly what that allegation is. That's generally what I'm looking for when I'm working through a disciplinary and looking for factual fairness, I think. So having covered factual fairness, of course, we then move on to your procedure. Acas Code. I won't go into a huge amount of detail about this. We all know the importance of the Acas Code, and I know in relation to where we are sort of post-pandemic world, Paul is going to come on to this a little bit later in more detail. Yes, the Acas Code is not legally binding, but if you don't follow it, almost every claimant lawyer I know I certainly do it, will put that 25% uplift on their schedule of loss without even thinking about it. In my view, the Acas Code, it is actually quite a minimal standard compared to what I think a lot of businesses do, certainly the bigger businesses, because it's drafted to accommodate every conceivable employer. So it's got to allow for the very, very small outfits as much as it does multinationals. I do think the vast majority of internal procedures go above and beyond what Acas generally allows. It's very much a skeleton framework. And then, of course, thinking of internal disciplinary procedures, yes, do follow your own internal disciplinary procedures. And the simple reason for that now more than ever before is because thanks to good work plan rules and the updates back in April, reference to your disciplinary procedures should be in your Section 1 statements, which means they're probably in your contract of employment. If they're not set out in detail, they should almost certainly be referenced and annexed to those Section 1 statements. For a long time now, disciplinary procedures which are generally followed and which it's expected that a business will follow have been deemed at least quasi-contractual by tribunals. The fact that they're now referenced in Section 1 statements and therefore in contracts of employment really just strengthens the position that an internal disciplinary procedure is going to be deemed contractual. What you don't want to do is miss following that and hand somebody a contract claim on a plate on top of their potential unfair dismissal. It will simply go to both points, and the contractual dismissal will be a lot easier to prove if that procedure hasn't been followed. I think what that means now, perhaps looking at disciplinary procedures and policies in particular, is where at various stages drafting has sometimes been quite specific, and we've often had this must do something within 5 days. The flexibility has become so much more important. We've got to accommodate for personal circumstances. We've got to accommodate for the fact that unexpected events like a major global pandemic might happen, and that therefore we need to change our policy and procedure perhaps midway through it. I think moving forward, I've always been a fan of this, as I've pretty much indicated when I'm talking about drafting anyway. Simple, plain English, flexible policies are going to be your friend moving forwards. By all means, the stuff the employee has to do can be a lot more rigid. Must appeal within 5 days is probably going to be absolutely fine. What you don't want to be doing is tying your own hands. What else have we covered there then? So procedural fairness, yeah, making sure we follow at least the Acas Code, making sure our internal procedure is fair and reasonable, that every opportunity is given to the employee to do and say what they need to do, to amend the process if we need to. And that all ties into my final sub-point there, consideration of the individual's dignity, health and safety. It's kind of easy to gloss over these, I think, when we're dealing with them internally and in the workplace, because they're largely common sense. We all know that a disciplinary process should be conducted in private. You're not going to have the meeting in a glass-fronted line of duty style room where everybody can see what's going on. But I think that extra step for that consideration comes in when we're dealing with these procedures remotely in the future. I won't say too much on this now because I think it will come out as part of a discussion point later with any luck, but we are starting to blur that line between home and workplace, and work becomes something invasive into your private life when that happens. Stressful work experiences impact on our home life even when we're working on site. It takes on a whole new dimension when your home is your workplace, as I'm sure most of us now know and are familiar with. What that means, yes, of course, your health and safety duties continue to apply to your employee while they're working from home, while they're suspended and going through a disciplinary process. And yes, in terms of general fairness, dignity is a relevant factor. How the individual has been treated and how they feel they've been treated will play a role. I think your decision is sorry, where am I? Yeah, so final test then applied by the tribunal pulls right back to that section 98.4, substantive fairness. And it's from this that we get our range of reasonable responses test. There's not much to say on this because it hasn't really changed much for a very long time since the leading case on it. But it is one of the few areas of employment law which sits, I think, slightly in the employer's favour. There's not many of them, as we all know, but I do think this is one of them. And that's because the tribunal is very restricted in the question it can ask itself, which is ultimately, was this decision somewhere within the options available to a reasonable employer in all the circumstances? It's a very open-ended question that they get the opportunity to ask. So whether a different employer might have come to a different conclusion, or even whether a different outcome might have been more reasonable than the one you reached, are pretty much irrelevant if the decision is somewhere on that spectrum. What the tribunal absolutely can't do, and it's an error in law to do this, is to say we would have. That's not an option that's open to the tribunal in deciding a fair dismissal. Personally, I think your decision is going to be more likely to be deemed reasonable if you can show throughout the process that you have contemporaneously considered issues which might make the process unfair and sought to remedy them. And really, I think the focus for the rest of the session is going to be on what those considerations are in terms of where we are with disciplinaries and dismissal procedures moving forward post-pandemic. That's pretty much me done on that. So I think, Paul, you're taking back over if your sound is now working. I assume it is.
Yeah, well, no, the sound was fine. It was the screen just went blank for some reason. It might have been when you
took over.
I don't know what happened. But anyway, thanks, Chris. So obviously, Chris is just to bring us all up to the sort of same level. I appreciate a lot of you would have known a lot of what Chris has just kind of gone through. But that was just a recap on sort of the basic principles of a fair dismissal. But of course, today, as we said, we want to look at sort of the processes and dismissals both during and after the pandemic, given that obviously the world we're in now is very different from that of 15 months or so ago. So this is our first sort of part of the open discussion points. We've put on this slide here some 3 sort of scenarios, which I'm sure some, if not all of you, have come across at some point over the last year or so with employees. But you may have some others that you want to discuss or ask questions about. But just running through the 3 that we've come up with. Firstly, you've got employee A who has been notified by Test and Trace to self-isolate, but ignores that and attends work anyway. Now, I know self-isolation is coming to an end, but of course we could have another wave and it could become appropriate again. And of course, it has been very recent that self-isolation has been around, and therefore you may have ongoing cases at the moment relating to this. The second one is employee B attends the office but refuses to engage in COVID secure measures, such as wearing a face covering or social distancing. Again, certainly myself, and I'm sure Chris has, we had specific cases of this from clients over the last 4 or 5 months, as we've opened up enough to be back in the office to a certain extent, but obviously still got the restrictions in place. And the third one is employee C is required to work from home, but there is a notable issue with their performance because obviously they're now out of the eyes and ears of people in the office. So that's the 3 sort of discussion. But as I say, we welcome people to introduce other ones. There are other ones, of course. But turning to the first one, and this is where we would like to encourage people to unmute and put forward their views and questions. Test and trace, self-isolation and attending work anyway. So firstly, has anyone had that experience? Any questions involving it? Michelle? Nope. Okay. Second one, well, let's look at all of them then, and just this in general. Has anyone got anything they want to raise regarding these issues? And then that will get us on to leading on to talking and advising about it.
Morning, Paul.
Gone.
Oh, sorry. Sorry, I was just going to say, I've had issues with a client that on the self-isolation part, but it was more that they were constantly being asked to self-isolate. So they constantly needed to not be at work. And that started causing issues about well, why are they apparently getting so many alerts saying you need to self-isolate when, you know, the average employee might not get any, or, you know, might only get told once. This employee was regularly apparently being told that they had to self-isolate because they'd been in contact with someone with COVID, and that caused lots of issues because we were starting to question whether they were actually genuine or not.
Someone's put in the chat about a good question about pay during self-isolation. So do you, and anyone else wants to come in here, pay when people are self-isolating? What's your policy on that? Because
for that particular client, we were following what I think was the government saying that we needed to do, was if they were self-isolating, they were being paid statutory sick pay from day one, which was above what would normally happen if they were obviously off, because they weren't entitled to contractual sick pay. But I have had another client that did pay contractual sick pay and was very worried about lots of people saying they needed to self-isolate. Thankfully, they didn't get it, but for that particular company, it did cause lots of issues with
Yeah, I do know that certainly a lot of clients did make the decision, especially if someone was self-isolating because of a health condition rather than because they were just getting notification because they've been partying that they're, they're at risk. I'm not sure why that employee kept getting notifications. But particularly when someone was perhaps self-isolating because of the health side of things, then yes, they made a decision to pay normal full contractual pay to avoid any sort of risk of any discrimination claims. I think that was quite common.
I was just going to ask, how did you approach that from an evidence perspective? Because I suppose that's an interesting one that I've had crop up a few times, is how somebody evidences that they've then been told to self-isolate in that situation. Especially if they were only receiving a phone call from Test and Trace and not sort of waving the app at you and going, look, I've been told to.
Yeah. So initially he was just saying, oh, I've been contacted by Test and Trace and I've been told that I must self-isolate because I've been in contact with someone that's got it. And like I said, this happened a number of times, and the first few times we were like, okay, that's fine, you know, the COVID cases are increasing, that's highly plausible that he has been in contact. But once you get into the 5th or the 6th time, then you're starting to question, really, you know, he's the only employee that has been contacted so many times. So then we were having discussions with him to say, you know, this is very odd, you know, you're the only employee that we've got that seems to have been contacted so many times. What are you doing differently? And, you know, we want to see some evidence now that you are actually being told that you must self-isolate. We're not just going to rely on what you're saying. And then funnily enough, I think we only have one other occasion when he did actually produce the app to say he's been in contact, but after that it kind of stopped once we started to say, no, actually we need evidence, it's not just enough for you to say.
I think that's reasonable, and as someone says putting this, you know, asking for screenshots or to show you the app. I know in the early days I was getting a lot of I never once got a sort of you've got to self-isolate or anything like that, but I was certainly getting lots of sort of weird notifications. And a couple of times I hadn't even left the house, and it was like, you know, you're the risk thing, and then a minute or so later you get another one through saying, almost immediately saying, well, there's nothing to worry about. And I don't know if that was the app or there was issues with it, but yeah, it sounds like in that case specifically that you needed to ask for evidence, and strange enough, when you did, the numbers went down. So that does sound an issue. People in the chat are talking about tests. Could you ask them to go through a test?
Yeah, we would now. I mean, this was happening very early on when it was incredibly difficult to get tests. So if that happened now, and it hasn't happened for a while, because I think is now so easy to get a test, you know, a number of my clients are now doing the whole home flow lateral testing. So these kind of things haven't come up for a little while. Yeah,
and of course you can't force someone to go for a test, can you? So
no. But actually that's an interesting question, maybe just by way of a quick poll in the chat. Is anybody taking advantage, or how much are people taking advantage of the free testing? Just if people want to give that answer or shake. I'm seeing a lot of shaking heads.
We've got a lot of people, a lot of our staff have children at school, so they're already doing the tests anyway.
Yep.
And we are very safe and secure here. We've done everything, risk assessments and everything. We've got 2 meters apart, and so to be honest with you, they're fairly safe in our building anyway. And we haven't got all the staff members in all of the time. Yep. So there's not many people in the building anyway. We're quite a small firm. But as I say, the staff that have children are already doing the flow testing at home anyway because of the children.
Yeah.
I think Amanda raised a really interesting point there about whether people potentially are hiding the truth behind the whether it be requirement to self-isolate or requirement to wear a face covering. Because I've got quite a few clients that are in the hospitality sector, and it was very clear that for them to be able to operate, they had to take the right precautionary measures with their staff, which would usually include wearing a face covering. And a couple of times I've had clients who have had staff who've refused to wear a face covering and then said, it was because they had some sort of either mental or physical health condition, which meant that they were exempt. And I think this really open to abuse, actually. And of course, there are lots of people who have genuinely got conditions that mean that it's hard for them to wear some sort of face covering, whatever. But there are also plenty of people who are using that as a reason not to do it. And then you've got a really difficult situation where actually the business needs them to do that, because they could be fined if they are shown to be serving people with staff who are not protected appropriately. And then there's no evidence coming through from that member of staff, and then you get into the realms of contacting the doctor, and that takes time, and then that's been really difficult, actually.
Yes, I've had one of those, and I even had a religion and belief case as well, whereby a client of mine's employee, one of the employees, was an anti-vaxxer and very strong opinions, and was refusing to wear a face covering. They did go down the disciplinary route with him because it was, the things he was saying were quite extreme, and actually he was disciplined more for the things he was saying, the inappropriate things he was saying, as much as refusing to wear a face covering. But yes, it's difficult. Your tools are the medical evidence, etc. But as you say, Rosemary, it takes time, and therefore, what do you do with the person in the meantime? Do you send them home? Well,
we did.
I was going to say after yes, because you've got to balance. I'm sure when it comes to justification, that you've got to balance up society, people, customers' welfare. And if they
would have been fined, the business would have faced
exactly.
a fine.
Well, I'm just saying it's not just the monetary value; it's the health side of things as well.
Absolutely,
I think it'd be more than justified to send them home, and so that is certainly the face social distancing side of things. Has anyone actually gone through disciplinary processes because of people refusing to wear face coverings or socially distance or just breaching protocols at work?
Hi, Paul.
Hi.
You can hear me. We had a recent situation, actually. So I work for a contract caterer. So we work on client premises.
Yeah.
And we work in care homes. So obviously, those elderly people are really vulnerable.
Mm.
And the client introduced testing. So all of our colleagues go in and get tested, before they go in. And recently we had one of our colleagues who refused a test on the basis of saying, well, I've been vaccinated, so I'm fine. So we had the conversation about, even if you're vaccinated, there's no 100% guarantee that you're not going to transmit that, virus to the elderly people. And actually it's the client's request. So the manager said, can we go down disciplinary for failure to follow, a legitimate, reasonable request? But in the end, we went more down the client removal through a dismissal for some other substantial reason, just because it's the client's premises, it's the client's policy. So, ultimately it's their decision really whether our colleague stays on site. And they said, look, until they get the test, we just can't have them work at this site. In the end, anyway, before we went down the end of the process, they then take the test. So I think that was enough. Yeah. But we decided to go down that route because it just seemed a bit simpler. And the client was saying explicitly, if they don't take the test, they can't be on site. So
yeah. And that brings back to what Chris was talking about, the reasonable responses test. And that's where you can use that in your favour. Yeah. Because I think, a reasonable employer, us people here, a good poll of that, we would say that's entirely reasonable. And therefore, as long as you went through a proper, procedure with that person, assuming they've got the requisite service, then, and we're not looking at discrimination today, then it's absolutely fine.
Yeah. And there was no reason they'd done the test previously, because we used to have the test. It was just their logic was, well, now I've had a jab, I've had the vaccination, so there's no need to do it. But that was. Yes,
I think that's been quite a common misconception. I think people conflate that I've had the vaccination, therefore I'm less at risk with I won't transmit it. We don't know that. Yeah. They think it helps, but unless you're a key scientist to know it all, then I can't see how you can say that.
Exactly.
Yeah. Okay, thank you. And what, anyone got any thoughts on C about any issues with people working from home? We've seen productivity go up, but has anyone had any issues on the disciplinary side now that they may have more people working at home, or clients with people working from home?
Definitely, I've had clients who have had to allow people to work from other countries, particularly while they have been required to, perhaps they've been visiting relatives over Christmas or something, and then they've had an extended stay because of what happened at the beginning of January. And it's been really difficult to manage performance from a very long distance, and they've seen a real issue with drops in performance. But how do you take that forward when you can't even, not even in the same country? Everything is obviously done remotely, so they haven't actually got to disciplinary stage, but they have started performance improvement plans on an informal basis, because clearly there has been a noticeable drop in performance. But also it's sort of on the other side of that, you've got somebody who's probably, they're not there by choice, they're there because they've had to stay in that country, and that's made it quite difficult. So I've encouraged them to manage the performance, and to raise the issues, and to sort of prepare for potentially using a formal process if they need to. And hopefully when they get back into the country, things will improve, but they're still going to be working from home. It's just slightly less extreme.
I'm going to come on to some of the specific issues and points relating to managing processes around a formal disciplinary with people remotely shortly. But I've had a case where, for example, a male employee had to go back to Poland because of an issue his wife had, family issue, and then got stuck back in Poland. And so he's been working for quite a well-known local employer. Now, fortunately, I think it hasn't been too bad. But there were some issues, and eventually it has led to a settlement agreement, which is where I got involved. But we've seen a few issues, and I know we've done articles and talks already on monitoring people at home. It's quite a sensitive subject.
I've also got sorry to Paul, just while I think about it, another example where actually somebody who works for my husband's company, a lad who's probably in his early 20s, who's basically been living, eating, sleeping, well, possibly not eating, and working in his bedroom, because that's the only space he's got in the family home, and that's affected his mental health. And it's affected his performance. And so the circumstances around your working from home setup, I think, are very relevant. And that has caused quite a lot of people's performance to drop, actually. Yes. So that's a really sensitive one to balance.
And you've got to take that into account, particularly if it's a long-standing employee who's always been very good normally, no issues at all. And then all of a sudden you've had a dip.
Yeah.
Again, a reasonable employer would be expected to consider those circumstances and take them into account when looking at, because as we all know, when you're looking at disciplinaries, you've got to look at mitigation as well. You've got to look at those points that are in the employee's favour that explains their behaviour, such that you perhaps won't give them as high a sanction as you perhaps would.
Absolutely.
If those factors weren't there. And I think that's a key one. Yeah, that is a key one.
They've been supporting him and encouraging him to take breaks, go outside, try and find things that will help his mental health rather than coming down hard on him, because support was the right way forward with him. It's not through a desire to be performing badly. It's more that the impact of this mental health on his performance. So.
And of course, you've got the flip side of that, and a couple of people are putting in the chat that now, of course, we're getting back into the situation where more people going back into the office. You've got that flip side where perhaps people are saying, well, I don't want to come back into the office now. It could be anything from a real health condition right down to sort of just anxiety of change. And, I've discussed it with friends and colleagues now, and it's very common at the moment that people are just a bit anxious about returning to the office, and not necessarily because they're going to catch COVID, but it's just another bit. They've got used to working from home for over a year, and again, it's managing those people sympathetically, but at the same time looking for those people who are trying it on and just trying to use the situation to get away with perhaps not performing as they should be. So that's where you've got to look at the different sort of tools that you've got as far as performance management and your policies to differentiate between those different people. I don't know, Chris, have you got any thoughts?
Only personal experience, although I'm following what's happening in the chat at the moment, is a really interesting conversation, because of course the return to work is a major issue. It's obviously slightly outside the scope of today's session, but it particularly just occurs to me how many days I've had in the office since July, which I think is in single figures, if my maths is right. And those 3 days I was in a couple of weeks ago, it was really strange. Particularly because we were having staff photos done, and obviously the whole firm was there. It was really weird to see everybody back. But yeah, I think the point that working from home, and it goes back to what I was saying earlier, I think, about when we're applying disciplinary processes, keeping that health and safety and that dignity of the individual in mind. Yeah, to use the example Rosemary was just given, I mean, somebody who is still living with their parents perhaps and working out of their bedroom, a disciplinary process going on over Skype or Zoom maybe. And we'll come on obviously to the practicalities of managing that in a minute, but it is an interesting one. I think that's a good time to just maybe move on and look at what some of our immediate thoughts were as well on these discussion
these
points.
are just very, very initial thoughts.
Yeah, these are literally the first 2 or 3 things that came into our heads in relation to employee A, B, and C there. I don't know if there's much to say there that we haven't already covered. Yeah, we talked about the fine in relation to individuals not following COVID rules. Did you know about the need to self-isolate? Yeah, that's where we've obviously covered kind of obtaining evidence, again, outside the scope, but GDPR requirements as well need to be borne in mind there. B, yeah, ultimately it's going to be what's causing the refusal, which again, we've discussed around religion, belief, medical reasons. And yeah, employee C, obviously the importance of managing it as a performance issue rather than a conduct one, I think is the main point there.
Yeah.
Okay.
They're just initial ones there, but okay. Thanks for the people who joined in then, because that's what we wanted, just to draw out some of the issues. Obviously, we can ask any specific questions that you may have. I see in the chat people are putting in some very good things there about use of charities, putting signs up, emailing staff. Again, like so many things in employment law and HR in particular, is communication, and the more you can do, and particularly when you have got people perhaps spread all over the place at the moment, as we say, as we go into June, then a lot of people will be going back into the office. But I do believe, as I think Fretton's will be one of them, we're probably going to have people certainly working from home part-time going forward. It's going to be a live issue going forward, which brings us on, if Chris goes on to the next slide. So I'm now going to just have a look at managing processes during COVID and beyond. Specifically, what I want, and I'm going to try and copy this into the, so yes, there we go. I've just put in there a link, because at the start there, and I must admit, a lot of this is, the Acas guidance actually has been adapted and changed and that ongoing, and is actually, it repeats itself in several places, but it's pretty good and helpful in terms of guiding employers in how to manage processes of disciplinary and dismissal during COVID. And the link is there if you want to have a look to the specific page where they talk about this. The important key thing, Chris has already covered the code of practice. It does continue to apply in full during the pandemic, irrespective of social distancing and other restrictions in place. So, as Chris said, it's a minimum really anyway. You should certainly make sure that you are complying with the code of practice, despite the fact that you may have the restrictions in place. Importantly, it was confirmed quite a while ago, someone on furlough can be asked to take part in an investigation or a disciplinary hearing. That is not classed as work and therefore breaching the retention scheme, the furlough rules. So obviously you still need to make sure that you are complying with it in every other way, but you can ask someone to be involved in an investigation or disciplinary hearing even while they're on furlough. So that is something else to consider as well. The main thing, and we talk about communication just now, is consulting with employees who you are looking to perhaps raise disciplinary action with them. First thing to do, as we often say in our sessions, is go back to your policies, make sure that Chris has already talked about flexibility, make sure they are flexible enough to allow you to deal with these new normal issues surrounding the pandemic and disciplinaries. Obviously, many organisations and individuals will be facing additional pressures, some of which we've already talked about, mental health, logistical issues involving people working from home. But a key thing to think about is, despite those pressures and issues, you do still need to act without unreasonable delay. We see an awful lot of times one of the key aspects of an unfair dismissal claim will be unreasonable delay, which can then lead on to grievances being raised, and then you've got both the disciplinary grievances going on and ultimately a tribunal claim. Despite the fact that the pandemic is here, and despite the fact people are on furlough, as I said, you can still deal with those people with investigations and hearings, and therefore you should still act without unreasonable delay. Having said that, you've got to find a safe, reasonable and fair way of acting at the moment. And as it says on the slide there, the key thing is to consider circumstances of each case. So the first thing to do is look at the people who are involved in the particular disciplinary situation you are facing. So you're going to have the employee who's involved, is the actual person you're looking to discipline. You've got to consider their representative or companion, and they're still entitled to be accompanied to any disciplinary hearing by a companion, a work colleague, trade union representative, who's known as the bare minimum, despite the fact that they may be at home and the companion may be at home. So you're going to have to look at logistical reasons around that, and other people involved as well. So perhaps the person chairing the meeting or other witnesses that you may need to attend, and either an investigation meeting or the hearing itself, to give evidence. First thing to do is basically communicate with all of those people and get their views, opinions, obviously putting forward your own good processes, just to check where everyone is in terms of their availability, their perhaps their IT at home. Can they attend video meetings easily enough? Have they got the technology to do it? Have they got the personal circumstances at home whereby they, perhaps if they've got children running around in the background, they're not going to be able to really focus on a disciplinary hearing, and all those sort of things. You may need to look for reasons whereby, unfortunately, you do need to perhaps delay or suspend a process, but at the same time, balancing that with sometimes doing that does make the situation worse. As people have already commented, we are now having more and more people returning to the workplace as workplaces become more and more open, as hopefully the risk lessens, and certainly when we get to June, theoretically we're back to normal unless something major happens in the next month and a bit. Again, look at your procedures and having safe face-to-face meetings. You've got to make sure you do continue to follow the guidelines, certainly up till June, but then you're going to get employees who perhaps got health concerns or vulnerable people at home that are going to still be concerned and anxious about having face-to-face meetings. So it may be even going past June the 21st, even if we are given the green light to return to normal, as it were, that you may still want to look at social distancing and face coverings in particular situations around disciplinary hearings, as well as any other meetings. It may be that you will still hold those meetings remotely. And as I said, you can look at video meetings. Obviously, companion these days, the way Zoom works, or whichever Teams, whichever you use, you can have companions and witnesses coming in and out. Obviously, with witnesses, you only want them to be attending at the appropriate time. They're giving their particular evidence or answering questions, but not being there for the rest of the hearing. So that all needs to be managed. As I said, make sure everyone's got the technology and access to those meetings, necessary equipment and internet connection. Maybe someone has a particular disability or accessibility issue involving remote meetings. So again, you need to look at that. Is it possible to get all the evidence you need for the investigation and hearing to the people? Obviously, normally when you're in the office and everyone's there, you've got your files there and everything, you can just hand it to them, give it to them a few days before, not a problem. Of course, at the moment, you've got to, send things securely, perhaps. Obviously, a lot of this will be confidential to the particular employee. You've got to be able to make sure that you can manage getting them the evidence, for example, that you've built up during the investigation to them securely, so that they can consider it and be able to defend themselves, for want of a better phrase, during the disciplinary hearing itself. Make sure witness statements are got to them in good time if they're involved, and as I say, have the opportunity to fairly question anyone involved in the disciplinary, not just the employee but other witnesses, in order to make sure that it is a fair process. Of course, you do have the advantage with videos, as we are doing today, that you can potentially record them. But obviously, make sure that the employee is aware of this beforehand, and that inform them you're recording, and that recording will be available to them after the hearing. Of course, there's a lot of advantages. It means you don't necessarily have such an emphasis on making detailed notes, because you'll hopefully have the transcript of the hearing. So there are some advantages to do that, but the key thing is data protection and making sure the employee has access to those recordings afterwards. As far as the chosen companion, you need to make sure that they are able, if they've chosen someone, to put and sum up the employee's case as they would be able to do face-to-face. Whilst they can't answer direct questions on behalf of the employee concerned, they can certainly, they have to be given the opportunity to liaise with the employee. And of course, in a room normally, they'd be able to have a chance to perhaps, whisper to each other, or talk to each other, or you go out the room and let them. You've got to make sure that that sort of facility is available to them remotely during the video side of things. So make sure that that's allowed, that they do have the opportunity to talk privately. Now, some of the software allows breakout rooms, etc., which obviously, if you've got that, that's great, use it. If you're using one of the more basic pieces of software, it may be that you have to log off for 5 minutes, 10 minutes, or they go into their own session and have that chat if need be. Those sort of practical issues you need to consider. Rules around companions in terms of their availability still apply as normal. So if they're, as a lot of you will know, there is a legal right to delay a meeting by up to 5 working days if a companion is not available. But of course, in the current circumstances, you may consider allowing a longer period of time if it's reasonable to do so. That's particularly important, I think, when you're looking at cases of disciplinaries that may result in dismissal, because again, that could be a key factor for an employee to raise as an unfair dismissal if, for whatever reason, it might be perhaps, particularly in recent months, the companion's had to self-isolate, or it's got things going on at home. It's not just the employee, it's the companion as well that you need to look at. All the way through the process, as I said, it's key that you make sure you don't have any unreasonable delay, but also do keep regularly reviewing whether you do need to put a suspended period of time in place if people have particular issues going on at home or around their personal life to do with the pandemic. And the other thing to remember is, as I said, the process is there in full, so you've still got to give them the right to appeal. So you may have appeal meetings that have got to be set up remotely as well, or if you have got them in the office, make sure that you've got secure processes in place as far as complying with the COVID measures at the moment. Going forward, I think this is going to be an ongoing issue anyway, particularly as, even though June the 21st is fast approaching, there's going to be people either still working from home a large part of their working week, or they're going to be anxious, certainly for the foreseeable future, about being on site. I think that's what I wanted to cover at the moment. Some of the issues around it. Again, it leads on to our next sort of our second and main open discussion point, which is doing some of these processes remotely. Again, it would be nice if people have got some comments or questions surrounding this particular issue.
Paul, sorry, I just think it's quite interesting actually, because while we've been doing any kind of formal process, because we still have colleagues working on sites, but we've been limited with us going to site to conduct meetings. So we've kind of got in the habit of saying, look, we'll hold it on site, or give them the option remotely. And that has worked really well, because logistically, because we're spread out everywhere, often it ends up being an area manager involved in that process, and they could be like hundreds of miles away. Yeah. So the process has been actually speedier for us, which means we've dealt with it more timely because of this, because of the option. But we would usually obviously have a note taker as part of that. So you're saying that if we use Teams, for example, and provided we get the authority from the colleague to record the session, we could just have the disciplinary manager and somebody recording the session, or would you say?
Yeah, there is an advantage, of course, of having a second person.
Yeah, to kind of as a witness. Of course,
if there's any disputed evidence on what was said, and although that's less likely with a recording, but nevertheless, sometimes you still get issues with, I don't know, things getting slid across the, who knows what they might say. Now, I think sometimes there's an advantage to have a second person in the meeting, but yes, it's less. I don't, Chris, have you had any issues yet with this?
No, I haven't actually encountered as a specific issue. No, but I think I agree with you. I think ultimately you could certainly do away with a dedicated note taker, but yeah, a separate observer on behalf of the business might be useful, certainly.
Yeah.
Okay. No, that's helpful. And I think you're right.
That's a good point. Actually, a lot of what we've learned in the last year and how we've all moved forward with the technology and that is actually it's giving us more options, and in some cases making it easier to conduct disciplinaries, grievances.
Yeah, because it's sort of working both ways, isn't it? We've said that a lot of the excuses about no, you can't work from home have gone, but yeah, it's working this way around as well. So of the advantages of knowing how things can be conducted remotely.
Yeah, exactly. Even things like, welfare meetings, a lot of colleagues who are off sick and aren't necessarily comfortable coming out of home, and vice versa. We've been able to do so much remotely. So I think it will change the way we work anyway, probably for the foreseeable. But yeah, that's just interesting. Yeah. Thank you. Yeah. That was it for me. Thank you.
Thank you. Anyone else got any considerations about remote disciplinaries? No. Any? Obviously, we've been on for an hour now, which I know is some people starting getting to the limit of Zoom calls and that. Any sort of more general questions around the current situation with disciplinaries and dismissals? Yeah, Chris is just putting up some of the things that we.
Yeah.
thought about. Yeah. Any other questions?
Well, I did a disciplinary hearing that was all done via Zoom, and it had to be rescheduled twice because the employee apparently had IT issues. Now, it all looked fine from our end, but apparently they had trouble hearing what we were saying. And you know, and I suspect part of it was because she was finding it all very challenging and she didn't know how to respond. So she would then say, oh, no, I can't hear you. I'm going to have to cancel this. So then it kept being rearranged. And I just think that was a delaying tactic on her behalf.
Yeah, it could well have been. And that's different. I suppose the advantage going forward, as we do open up, is you will have the two options.
Yeah.
So, as we've just said previously, it might be beneficial. Someone might actually be more comfortable sat at home rather than in an office surrounded by 3 people, you know, HR and manager and a note taker and everything, whatever. They might feel more comfortable in that. Whereas there's going to be other people where you think, well, actually, it's going to be better to bring them into the office, or if they are in the office, and doing the meeting, and hopefully, in the next, it's happening now, but certainly from June, you'll have those options. Because that I'm sure there are going to be people who, hopefully, is in the minority, but you're always going to get that person who's going to use the situation to delay and everything. Yeah. And I think it's frustrating, but I'm not sure. Certainly, it sounds like you did the right thing. You've got to give them a couple of, you've got to give them the benefit of the doubt a couple of times at least. Yeah. But I think it's all fairly positive now. We've got all these options that people weren't really using before. Any other questions on?
I was interested to know if many people are relaxing their rules around allowing, say, a family member to join them as a colleague, as their representative, if you like, to the companion. Obviously, given that people are at home, we have now, allowed that, the partner or whoever it might be.
Yeah.
Is that common?
Well, I don't know about Chris. We haven't talked about this recently, but I've got quite strong views on this. I've always had, and some of you may have heard this before in some of that when we've talked about disciplinaries and grievances before, but I do have a little bit of an issue with employers who just rigidly stick to the trade union reps and work colleagues. Tribunals won't like that unless you've got a good reason to say no to the family member. And obviously there will be times, particularly if it's a young person or a vulnerable person or whatever, that you actively should allow it. But I think even in normal circumstances, if someone says, oh, can I have my husband or wife or sister, whatever, unless you've got a good reason to say no, and there will be some, it could be very, very sensitive, confidential, or if indeed a person does become disruptive and causing trouble, then of course you're well within your rights to say, right, ask you to leave the meeting or adjourn the meeting and you have to find another companion. But I don't know about Chris, but my personal opinion is unless you've got a good reason to say no, then I would allow it anyway. And I don't know if anyone else wants to come on and give their thoughts as well.
Well, I'll answer first. I absolutely agree. I think it's what we've been saying all the way through. You've got this absolute minimum standard that is either imposed by statute or by the Acas guidelines, whichever issue we're dealing with. The more you can do above that, the more you're ticking that fairness, reasonable box, unless it is entirely unreasonable, as Paul says, for it to be someone beyond sort of trade union or colleague. My view really is that the purpose of that statute is no, they can't turn up with a lawyer.
Yeah.
Basically.
And even then, there are certain situations which we're not going to cover today where they are entitled to a lawyer, but it's very specific and
yes.
quite rare. But exactly.
Yeah, I mean, happy to open up that question as well. Please, by nod, shaking of head, yes, no, in the chat box. Do people generally extend out beyond trade union rep colleague?
I have. Even going back years ago, I've allowed parents or husbands, wives to attend. But I always make it very, very clear right at the very beginning what they can and can't do. And I've said, you know, quite openly that this is what you're allowed to do. This is not what you're allowed to do. And if I feel that your presence is being unhelpful or disruptive, then you will be asked to leave. And I've not had any issues with, you know, parents or partners attending.
But you'd have to do that with a companion who perhaps, let's say one of your employees says, right, okay, I want to bring my mate Bob, who sits next to me at work. Bob might be a junior employee who has no ideas about disciplinary grievances. You'd have to inform him exactly the same stuff anyway. You'd have to say, right, you can do this, you mustn't be disruptive. Yeah, it's interesting. Some people are coming in the chat box. I still see it, even in recent years, you know, when I'm acting on behalf of claimants, employees, you know, their employers have been very like, no, trade union rep or work colleague, you're not entitled to anyone else. And I've had some clients, and I've had to say, and I always say to clients, no, be more flexible, I think, personally, and as Chris has agreed. But no, it's interesting that people are putting in the chat box that they do now. I think it is shifting in the last 2 or 3 years, that people are realising, because tribunals do not like it if you are that rigid. Just because the statute says that, that's, as Chris said, that's the bare minimum. Yeah, so it's a good question. Yeah. Anything else around this?
No.
Otherwise, we will thank you, everyone. Now, obviously, we've talked about the new normal, we talked about June and everything. It would be interesting, and whether you want to put it in the chat now or consider it and let us know afterwards, we're probably going to send out a specific feedback on this, because we always ask for your feedback. Obviously, the next session, which is now, because of the summer holidays, we always hold slightly later, won't be until September, will be well after, hopefully, the restrictions have eased. And therefore, we are considering returning to a face-to-face training event. But of course, we would like people's opinions. It may be that we do both going forward, or we have a face-to-face, but now we've got the technology much more up and running, we record them as well, so people can perhaps join in remotely as well as having it face-to-face as well. Be interesting to get your comments on whether you would feel comfortable returning perhaps to a hotel at the moment, face-to-face and such. So we would be grateful if you could do that, but we are probably going to send out a feedback. Someone's already put in, Piers already put in the chat about alternate. That's exactly one of the options we were thinking about. It was Chris who actually raised the potential good idea. Well, could we have the best of both worlds and have it recorded at the same time, facing us, so that people can log on and watch the recording as well as be in the room as well. Several people saying we're really keen to face-to-face. I prefer face-to-face, obviously. I'm sure Chris does. So it would be great if we can do that. Best of both worlds coming up. Yeah, face-to-face. So that's great. Yeah, lots of good. It looks like most people are saying either face-to-face or both, which is exactly what our thinking is as well.
Yep.
Okay, so that will get Jenny on the case, because she's doing the logistics of booking. Because of course we've let all our sort of agreements with the hotels and that lapse, I think, I'm guessing. So we're going to have to look into that. But yes, that would be great. Any final questions? Otherwise, as Chris has put up there, there's our contact details. If you prefer to ask any questions after the session, please drop us a line or give us a call. Otherwise, we wish you continued good health and be safe, and hopefully see a lot of you in the near future, perhaps face to face.